sorry, a little bit off kilter, but people have been coordinated to get back to normal routines. Who is the state's attorney? Thank you. Would you call your case, please, ma'am?
Yes, Your Honor. So you don't understand, right before you took the bench, the victim's grandfather went to use the restroom. He may walk back in, but he's the only victim in his attendance, and it's just unfortunate timing, but he can just step out. I don't want the court to be aware of that. I'll send this hanky after him, all right?
Which case is this, please?
My name is Minnie Lipinski. I'm with the Solicitor's Office, Your Honor. I know you don't recognize me. I was here.
I recognize you. I just want to know what case we're here.
No, that's fine. We're here on Travis Devon Jones, warrant number 2020-A04-1010-085.
Do me a favor, please.
Okay. All right.
I know we need to have them all back here.
That's fine, and I know it muffled, so I apologize. The state is here on a bond hearing on Travis Devon Jones, pursuant to warrant number 2020-A04-1010-85, charged in the offense of homicide by child abuse. He was arrested earlier this summer, Your Honor. He has been held without bond. He is represented by Mr. Richard Water.
Where's Mr. Jones?
He's on via teleconference, Your Honor. And Mr. Water, if you want to stand, we're doing it a little out of order, but I believe if you stand near the court reporter, you might be able to hear better than your client can see you.
But I have no trouble hearing anyway.
Mr. Jones, can you hear me okay?
Yes, sir.
Mr. Jones, do you understand that you have a right to be physically present here in the courtroom today?
Yes, sir.
Are you agreeable to having this matter heard with you being on closed circuit TV and your attorney here in the courtroom?
Yes, sir.
You do so freely and voluntarily?
Yes, sir.
Okay, raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, sir. And again, I don't know that we'll need to hear from you, but you are agreeable to having this case disposed of by way of closed circuit TV?
Yes, sir.
If at any time you need to speak with your attorney, would you speak up? I'll stop, and he will be able to contact you by way of phone on a private line, okay?
Okay.
Give me the facts of the case, please.
May it please the court, Your Honor. These events allegedly took place back in June of 2015. The victim's mother, Kiera, left her two minor children, Ariel and Leona, in the custody of Travis Jones at approximately 10 o'clock the morning before. She was going to be away from the home as her sister was getting married, and so she was going to participate in all the things that lead up to your sister's wedding in terms of pre-wedding events and those type of things. So they were left in his care approximately 10 o'clock the morning before. She would have phone contact with Mr. Jones on and off throughout the day, but that, to the best of our knowledge, did not return home until approximately 4:30, 4:45 the following morning, so June 6th of 2015.
Go back. She left at
10 a.m.
10 a.m. the day before.
The day before, and she returns approximately 4 a.m. the next morning. So just shy of about 18 hours or 20 hours is about the time frame we believe she's away from the home.
From the state's investigation, was the defendant taking care of the child all this time?
They were left in his care, yes, Your Honor. He is seen on surveillance video in the apartment complex without the children, intermittently throughout that period of time, but he is the one she believes is taking care of the children the entire time. There were no other babysitters and no other adults in the home that were in a caregiving role during that time.
And any surveillance showing anybody else entering residence?
The surveillance cameras are not it's an apartment complex, and so that particular building does not have specific enough surveillance cameras that you could say they went into apartment A or apartment 1 solely that you could somewhat see during daylight hours cars approaching the building and leaving, but they could have gone to any number of the apartments in that complex. Thank you.
What kind of record offending does this gentleman have?
He has a little bit of a record dating back to 02, which was mainly minor traffic offenses, although there was a failure to appear in 02. He then pleads guilty to burglary first degree, accessory after the fact, and a grand larceny for which he got a split sentence. He does some active time and then he's on probation. In 2012, that probation is violated, mainly for traffic offenses and also a possession of cocaine first offense charge. Then in 2014, his failure to appear, a criminal domestic violence, the cocaine probation is violated. In 2015, he gets a 3-year sentence on a violation of parole, so not new charges. But 2015 is also around the time that these events have happened. There's a 3-year-old in the home, Ariel. She tests positive for drugs pursuant to this investigation. As a result of that, he is charged with unlawful conduct towards Ariel, the 3-year-old sister.
Is that pending or is he playing?
He pled guilty and he did a 3-year sentence. So he got probation violation and a 3-year sentence on that unlawful conduct charge. He's then released. He's charged with a child support charge in 2017. In 2018, he gets some minor magistrate offenses along with an unlawful carrying of a pistol. In 2019, so September of last year, he pleads guilty to 2 charges of distribution of meth, first offense, for which he gets 10 years suspended on 175 days and 5 years probation. At some point, there's also, I think, a magistrate failure to appear last year as well. He's currently, under my understanding, I checked with probation, he's still under that probationary sentence.
So according to my notes that you give me, maybe I'm wrong, he has 3 different failures to appear.
Yes, now most of those do, 2 misdemeanors, but most of them do appear in magistrate court, not candor to the court, but he does have failure to appear charges on his record.
Where's the state as far as Mr. Brown's case?
Your Honor, this took over 4-year really 5-year investigation. I believe I'm through the bulk of it, and we'll be ready to make a prosecutorial decision on how we will proceed soon. I would anticipate that decision hopefully coming in the next 60 to 90 days. I've got a few things I'm following up on. Could be even sooner than that, but I think that's the worst case scenario where we either try and work something out with the defense or we go forward with a charging decision, grand jury indictment.
All right, so we're glad to hear from you.
Your Honor, of course, this is not only an old case, my client has been around with knowing this investigation was going on. And certainly, I don't think he represents a flight risk. No significant contacts outside of the state. There's a couple of failure to appears, and I think part of them are traffic tickets and stuff like that. No evidence of flight involved other than just didn't make the
It
appearance.
sounds like that as well.
Yeah.
What are his connections to Anderson County?
What's his what?
What are his connections or ties to Anderson County?
Yes, he's married, his wife is seated in the courtroom here today. His family is from here, parents are here.
Was he born and raised here in the county?
Yes.
Okay, that's right.
He's a mechanic, works in a business of his own. Children, he has a total of 6 children. He's not only lives here, he's well rooted in this county. These are charges that we have no idea what they're based on. We haven't got any discovery that I stand here with not the first.
Well, have you submitted to Rule 5 and
Yes, sir, it's been over 30 days.
why has he not received his discovery?
I spoke with Mr. Water. It's quite voluminous to the extent of a bank. I understand that, and I told him I would.
The question is why?
I'm working on it, and we will get it to him. And I told him I would have it to him.
You'll have it by Friday at 5 o'clock.
He will have it by Friday at 5 o'clock. And I also spoke with Mr. Water and offered to answer any questions that he would have prior to this phone here. I understand it's not the
He's
same.
gotta look at the discovery.
I understand,
He's gotta
and we
look
will
at
get
the
it. And I apologize. Part of that, Your Honor, is it is just the corona and low staffing. And but I did not get a full file from law enforcement myself, so I've only recently gotten some of it. I've got to wait through it, but I will get it to him as quickly as possible. I understand. I just want the court to know it's not dereliction. It is merely the volume of information provided. But we will get him on his way.
All right, 5 o'clock on Friday. If you don't get it, you'll get it, I'll push. Okay. Now, at this juncture, board, submit this charge in this case. I'm not going to give him a fine. I'm going to leave that without prejudice to you once you get your discovery, wait through it.
appreciate that, but here's the dilemma that from the defense perspective we have. We have this form charge, that comes up, and I don't know what politically goes on, but there's no one that can say why they decided to charge him, what happened at this time, what is here. And as the newspaper reported, when asked the solicitor's office about it, they say that they were reviewing the case to see whether it should be prosecuted, and the Anderson County Sheriff just went and got a warrant. They considered it unusual. I don't know whether.
Let me say this to you, in all due respect, and I've been in you for a long time. I don't know anything about any of that. I'm not privy to any of the documents or any of the discovery of this matter. And at this juncture, without having more information, I'm not inclined with homicide by child abuse charge to grant bond. And I'm not saying I wouldn't. I'm just saying right now, I will not. And if you can show me, once you get your file and you review it, that it should be granted based on whatever particular reasons you find, I'm happy to review this matter at any time. But right now, I am not going to grant any bond. Okay, so.
Okay, John, allow us to quickly do it.
Say that again.
If you're not going to allow us the privilege of addressing the bond whenever we get discovery and have.
You can file it tomorrow morning if you feel like it's appropriate. I'm just saying right now, based on the information I had before me, this prior record, the charges in this case, I'm not going to grant on the case.
Okay,
All due respect, Mr.
Solicitor, then.
Thank you, sir.
We're good on it. Thank you, Your Honor.
Yes, ma'am. Please get him that discovery.
I will, Your Honor.
by 5 o'clock.
I will, Your Honor, and I will go back and forth to Greenville if I personally deliver it. I'll make sure to
Got
have it.
it. Thank you so much.